When a lawyer is in court representing a client, we have rules that require strict truthfulness on certain points. That may even require the lawyer to volunteer information or disclose something that the lawyer would normally keep confidential outside of the trial setting. Model Rule 3.3 sets forth the lawyer's truth-telling duties toward a judge or similar tribunal. We call it the duty of candor to the tribunal or toward the tribunal. So let's dive in. Model Rule 3.3a1 says, a lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So note that if the judge asks you a question point blank, you're simply not allowed to lie in court. You have to answer truthfully, even if your client doesn't want you to. Sometimes you may have said something inaccurate to the judge. Perhaps you absent-mindedly misspoke, misremembered something, or maybe you thought you were answering correctly, but discovered later that evening that someone had lied to you or misled you, and you inadvertently had repeated that false information to the judge. So if the trial is still going on, in that case, you have an affirmative duty to proactively correct that false statement you made. Maybe ask the judge for a moment to address the court and say you misspoke earlier or stated something you later learned was untrue. Note that it has to be material to the case. It could be about facts or about the law. If you misspoke about something that has no bearing on the case, like where you plan to go for your upcoming vacation, you don't have to correct that. Rule 3.3 continues with section A2, which is about not hiding adverse legal authority. A lawyer shall not knowingly fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. And then this can continue, but first let's talk about this. Let's say that you're researching cases before trial for a brief about, let's say, a motion for summary judgment. And to your dismay, you find a case that's right on point and is horrible for your side. And it's controlling precedent in your jurisdiction. Maybe it's a decision from the state's highest court. It could also be a statute that you didn't know about. And then, incredibly, the opposing party somehow missed this case that is so favorable to their side. Well, you don't get to hide that case or bury it. Whether you like it or not, you have to disclose it to the judge, which means you'll also have to disclose it to opposing counsel. Now, you can go ahead and try to distinguish it from your case in some way, but you can't pretend it just doesn't exist. Now, let's talk about how this happens. Some lawyers are just sloppy in their legal research, or they entrust their case research to a law student intern who doesn't know what they're doing. So maybe that's why the other side missed this case that's a winning case for them. Or maybe the opposing counsel just reused a brief or sections of briefs from other lawyers in their firm that they had filed in similar cases. That's very common. Maybe without checking the cases or doing any of their own research. It happens. And again, remember that this can happen with unfavorable case precedent or with a statute or some sort of controlling regulation or codified law. Now, if you find unfavorable cases that are merely persuasive authority, this rule doesn't apply, and in that case, you wouldn't have to disclose it. Watch for test questions that make that distinction. Rule 3.3a3 says that a lawyer cannot knowingly offer false evidence or evidence that the lawyer knows to be false. It says, if a lawyer or the lawyer's client or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. Then it keeps going. A lawyer may refuse to offer evidence other than the testimony of a defendant in a criminal matter that the lawyer reasonably believes is false. So, in other words, if you're doing a trial, you are not allowed to fabricate evidence or forge documents or call a witness that you know will lie on the stand or submit an untruthful affidavit. Note that this rule refers to evidence that the lawyer knows to be false. So here we're talking about actual knowledge, so although we can infer knowledge from the circumstances. That means, though, that if the lawyer just merely suspects the information is false, like you doubt it, this prohibition doesn't apply. You have to actually know that the information is untrue for it to apply. The second part, however, is for situations where the lawyer believes but does not know for certain that something is false. You may offer this as such evidence, but you may also refuse to offer it, even if the client wants you to, and you would not be subject to discipline for disobeying the client's directives in that situation. We'll talk about perjury some more in a follow-up video and cover some more details about it, but for now, let's move on. A lawyer who represents a client, this is section B, in an adjudicative proceeding and who knows that the person intends to engage, is engaging, or has engaged in criminal or fraudulent conduct related to the proceeding shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. This could be perjury. Let's say you learn after court adjourns for the day that a witness you called committed perjury on the stand, or that your client is bribing or threatening jurors or witnesses in the case. Both of those are criminal scenarios. You either need to convince the person to confess that to the judge, or you may have to betray your client and disclose it over their objection under this rule. Let's move on to subsection C of this rule. The duties stated in paragraphs A and B that we've talked about so far continue to the conclusion of the proceeding and apply even if compliance requires disclosure of information otherwise protected by Rule 1.6. That's the duty of confidentiality. Now, the first part of this is good news for the lawyer. Let's say the trial ends, the jury's been dismissed, and your client calls you the next day and tells you that they lied on the witness stand or gave you forged documents to submit as evidence. If it's all over already, you have no duty to disclose this. But the second point here is very important for test questions, especially the MPRE. I think that the MPRE will probably give you several hard questions that kind of pit the truth-telling rules like this one against the duty of confidentiality and ask you to choose which rule controls in the hypothetical scenario in that question. These are tough questions because you're trying to pick between two rules that you know. So keep in mind that Rule 3.3 wins over Rule 1.6. In other words, in court, the duty of candor outweighs the duty of confidentiality. So next, there's one last section of Rule 3.3 I want to talk about in this video, and that's D. In an ex parte proceeding, a lawyer shall inform the tribunal of all material facts known to the lawyer that will enable the tribunal to make an informed decision, whether or not the facts are adverse. Now, the most common type of ex parte proceeding is a preliminary injunction hearing or a temporary restraining order. Typically, only one party is present in the courtroom with the judge for these. The other party will have an opportunity later to have their day in court to contest it, but due to the emergency nature of injunctions, we usually allow the initial injunction hearing to proceed with only one lawyer present from one side. If that's you, in such a case, you actually have a duty to offer facts favoring the other side that normally you would not have to offer if the other side were present. The idea is to make sure the judge is aware of the most important facts on both sides for temporary restraining orders and preliminary injunctions. Now, you can still argue that your side is right and that the judge should rule for you. But if there's a big fact out there that would be the obvious counterweight to your side, you have to actually volunteer that and hope that the judge still rules for you. Hopefully the facts on your side still outweigh that unfavorable fact. And now also keep in mind that if the other lawyer is present, you don't have to volunteer facts on their behalf. Now, before we end this video, let's talk about just the first few ABA comments to this rule that might appear in test questions. Comment 1 says that Rule 3.3 also applies in ancillary proceedings, such as a deposition. So that means that Rule 3.3A3 requires reasonable remedial measures even if the lawyer discovers that false testimony was offered in a deposition, right? So that you're in a deposition, your client lies, you're still going to have a duty to correct it somehow. Comment 4 is about specifically legal arguments. A legal argument that's based on a knowingly false representation of the law is considered dishonesty toward the tribunal. In other words, as we said before, do not just make up cases or tell the judge that the legislature has never addressed a question, that the statutes are silent, if you know that there's actually a statute on point. On the other hand, you're not required to make a disinterested exposition of the law, but you must recognize the existence of relevant legal authorities. So we're not saying that you can't advocate for your side of the case, but you can't hide the relevant law as part of that. You can't be misleading. You can argue in favor of your side without hiding the law that might support the other side. Now, comment 5 is about refusing to offer false evidence, and it means basically a point of tension between you and your client. Rule 3.3A3 requires the lawyer to refuse to offer evidence that the lawyer knows to be false, regardless of the client's wishes. And comment 5, moving on, is about evidence of falsehood. So a lawyer does not violate this rule if the lawyer offers evidence for the purpose of establishing falsity. So, for example, let's say you're trying to prove that someone committed forgery or tax fraud. Well, to do that, you're going to need to offer the forged documents or fraudulent tax returns to prove that. So even though in some kind of philosophical sense, you're submitting falsified documents into evidence, the obvious purpose is to prove that they're false, not to support the lies themselves. So that's okay under Section D. Now, this ends the first video we have about Rule 3.3. We will have a follow-up video with some more details, especially how to handle clients who commit perjury on the stand at trial.